The acceptance of appointment of a guardian ad litem for an alleged incapacitated individual. Hi, I'm Darren Findling of the Probate Pro. We're going to cover Form 627. This is SCAO, State Court Administrative Office, Form 627. It was revised in Michigan in July of 2024, replacing all earlier versions. It's important to use the most up-to-date version to ensure that the court will allow it for filing. The bottom left corner in purple where the arrow is, there is a reflection of the revision date and the form number, as well as the statutes and court rules that apply to this particular form. It's really important to review the statutes and court rules to ensure that the form is being completed appropriately. Now, this form is used by an appointed guardian ad litem. This is an individual, it could be a lawyer or non-lawyer, appointed by the court in regard to a petition for the appointment of an alleged incapacitated individual. An incapacitated individual is an adult, not a minor. So this would be a guardian ad litem petition that has been filed, a petition for guardianship that has been filed for an adult, and a guardian ad litem has been appointed. This would be the form used to say, I, as guardian ad litem, have accepted the appointment and I'm reporting to the court on the following. Remember, the guardian ad litem is the eyes and ears of the court, allowing the court to get information, more detailed information, home visit potentially, and other medical related information to fully understand what is before the court when a petition for appointment of guardian has been filed. Let's work our way through the form. Top left corner is the county probate court. Top right is the case number and the judge. And then we've got the court address. In the matter of is the name of the individual who is being sought guardianship over. Paragraph 1 provides that I have been appointed by the court as guardian ad litem, or GAL, we say, and I accept the appointment. Because you could get appointed as guardian ad litem and say, I decline, I have a conflict, I can't be involved. 2, I perform the duties by statute. And the next page, page 2, is a delineation of all of the statutory requirements that a guardian ad litem must do to fulfill their reporting requirements and their performance of their duties as guardian ad litem. 3, I visited the alleged incapacitated individual on, and that's the date and of course the location of that visit. And then it goes on to say that to the extent the individual could comprehend, explain the nature, purpose, and legal effects of a guardian's appointment and otherwise complied with the provisions of the statutory basis of 700.5305, subsection 1. Now, this is important because there are some individuals who a guardian ad litem may go out and visit and who could fully communicate and discuss the petition that has been filed. And there are some that simply because of the nature of their health issues may not be able to comprehend it or communicate in regard to it. But either way, whether they can communicate or not, it is the duty of the guardian ad litem to fully express the advice of rights, the information that is contained within the petition to ensure that they are fulfilling their duties of communicating to the alleged incapacitated individual of the petition for appointment of guardian. 4 indicates you're reporting to the court about whether the individual has communicated, whether they want any limitations on the guardian's powers if the court were to appoint a guardian, whether they are agreeing to a do not resuscitate order. There's a specific provision of the Michigan statute that addresses the DNR requirements, as well as physician's orders for scope of treatment. This, again, particular provisions of the statute that define exactly what a guardian must do for purposes of having the authority for these particular types of decision making, as well as whether the individual is interested in contesting the petition, objects to the appointment of the nominated guardian or the designated or standby guardian, or have an attorney appointed. Now, this form was modified primarily to address the change in Michigan law for the appointment of a standby guardian. This standby guardianship concept did not exist with adult guardians before this revision. So this is why primarily this form was adopted. It allows the guardian ad litem to identify whether they object to the petition in its entirety, to the appointment of a guardian, as well as the person nominated to serve as the guardian or standby guardian. Section B indicates there's a disagreement or dispute related to the guardianship, and there's a provision or a space there for this information to be shared, and that it may be resolved through court-ordered mediation. The idea being that if the court sends the parties to mediation, could mediation resolve the dispute about this guardianship? So, for example, if there's a guardianship and there's two people that are seeking to be served, and the person is asked about it, and there's a dispute, and the guardian ad litem believes that maybe court-ordered mediation with a professional mediator could resolve the dispute between the parties, then that box would be checked. And paragraph C indicates whether there's appropriate alternatives to full guardianship. Now, for example, there could be a patient advocacy in place or other provisions in place that would avoid the necessity of guardianship. So remember, guardianship is the court-imposed process, but you could also create estate planning documents that provide for many, if not all, of the opportunities for a decision-making relating to a person who is vulnerable in need of protection relating to these types of decisions. As we work further through the document, it indicates whether the person who is being sought guardianship over is agreeing to the guardianship or objecting, as well as whether they wish to be present at the hearing. And they can waive the presence of that individual at the hearing. Many people who are being sought guardianship over are not in a healthy enough situation to be able to attend a court hearing. And although it is their right to have a court hearing as well as present all evidence and hear all evidence in regard to the petition. And you can identify under paragraph E, it is believed in the best interest of the individual to have legal counsel, and you can identify the basis. Now, an example of the basis for legal counsel would be an objection to the appointment of a guardian and or the nominated individual. Or you can identify whether the individual has expressed that they're intending to obtain their own legal counsel versus an appointed counsel through the court. Paragraph 5 indicates if none of the items of 4A are demanded, and you can then, the guardian ad litem can fully attach a report. Now, in some courts, the guardians ad litem do not even use this form. They simply do a full narrative report, and in some courts, it is the expectation that this scale form is utilized in addition to the full report. Then the guardian ad litem would sign with their full information below. On the back of the document, this is the identification or description of the various statutory responsibilities that exist for a guardian ad litem. One, that they're doing a personal visit, that they've explained the nature, purpose, and legal effect of the appointment of a guardian. They've given the form PC 626, which is the notice of rights. This is a full description of the rights. So instead of just verbally expressing by the guardian ad litem to the alleged incapacitated individual the rights that they have as it relates to the guardianship proceeding, they are left with a document. So, for example, somebody may not be awake or conscious during the time the visit occurs, but they are now left with a notice of rights that they could read at a later date, as well as other family member or advocates could help them understand their rights that are set forth in the statute. In addition, that as we move to paragraph 5, it talks about the rights relating to the hearing on the petition for guardianship, including the right to contest, the right to request limitations, the right to request the particular nominated individual, the right to be present at the hearing, the right to be have legal counsel, as well as the right to have a legal counsel appointed if the individual is unable to afford hiring their own lawyer. In paragraph 6, it talks about that the guardian ad litem has the duty to inform the individual of the name of the person seeking appointment as guardian or the designated standby guardian if that applies, as well as ask the individual about whether there's any cash or property convertible into cash in the estate. The idea being guardianship is for care, custody, well-being. There may be a need for a conservatorship, or within the guardianship there may be need for protections for those assets. As we make our way to paragraph 8, it talks about the determinations that are going to be informing the court. These are all the things that are statutorily required, whether they wish to be present, contest, etc., as it relates to limitations of guardianship powers, as well as alternates to establishing guardianship. So there could be a discussion with that individual about alternatives that are avoiding court intervention and involvement short of a guardianship. And that provision here on the backside identifies the statutory obligations of the guardian ad litem to express that to the alleged incapacitated individual, as well as what we discussed earlier, whether the disagreement or dispute could be resolved through court-ordered mediation, and then that the identification of this information is generally done in a full descriptive narrative by the guardian ad litem and attached. So typically we see a full narrative attached to this petition or a full narrative that is separate and distinct from this document. Often the courts don't require it, so we see sometimes the courts wanting it, some they don't. At the Probate Pro, we are passionate about everything probate. If you've got questions about this acceptance of appointment and report of guardian ad litem or any probate or trust related issues, visit us at theprobatepro.com or call us at 833-PROBATE.